Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we have picked up a couple of important articles which are very significant from your UPSC and your KPSC examination point of view. Before we understand what these articles are in greater detail, a quick gentle reminder. Spardha Lines would be launching a new test series for all those aspirants who would be taking up CTI, PDO and KAS exams. So these exams, one of the important components of these exams are the current affairs. So in order to equip you so that you would be able to answer these current affairs questions, what we are coming up with is a test series where the current affairs test 1 will be conducted on 26/11/2023. The current affairs test 2 will be on 3/12/2023. Current affairs 3 will be on 10/12/2023 and current affairs test 4 is on 17/12/2023. What is that you have to do? Link will be given in the description box. Given the necessary information and you would be able to take all these test series free of cost, and this is available both on the offline as well as on the online pattern. And you can take up this examination in English as well as in Kannada as well. Let's get started and look into the first article. Before we start with the first article, I have a request. We put in a lot of efforts to bring the best content possible for you all so that you would be able to understand these concepts in a simplified manner. So what is it I'm looking for? You have to make a payment. Payment in terms of what? All that you have to do is make the payment by liking these videos, sharing it with your fellow aspirants and also subscribing to our YouTube channel. And this article here is speaking about the special category status. What is the special category status? Why are we discussing about it? That is because the Bihar Cabinet approves resolution demanding special category status for the state of Bihar. Now the question is, there are two types of states. One is what is called a special category status. The other is what is called a special status as it was given to Jammu and Kashmir. And we also have some of the states, let's say for example, Maharashtra and Gujarat under 371A, 371B, 371C, 371D, so on and so forth. When we speak about these kind of status, what is the difference? When we say special category status, the special category status is more economic in nature. The special category status is more about providing some economic status as well as providing means and mechanisms so that the state is able to empower itself on the economic front over a period of time. That is what is called a special category status. But when we say special status as a whole, what exactly happens? We have, let's say for example, the state of Karnataka. In the state of Karnataka, we have Article 371J. It speaks about the Hyderabad Karnataka region. It provides certain economic considerations as well as reservations for the people belonging to Hyderabad Karnataka region. So when we say special status, it basically provides certain political nuances. It provides some of the advantages in terms of the reservation, political merits taken into consideration, political manifestations that can be provided for a specific state. So 371 also has couple of other states as well, A, B, C, D, so on and so forth. So we have the state of Gujarat, we have the state of Maharashtra, we have the state of Nagaland as well, where political initiatives, legislative mechanisms are provided to these kind of states. That is what is called a special status. And earlier we also had Article 370 as well. Now that we also have Article 370 which is diluted, a special status was given to the erstwhile state of Jammu and Kashmir. Now the state of Jammu and Kashmir, this Article 370 has been diluted. So the special status which was once given to the state of Jammu and Kashmir is not given now, but earlier it was given. So when we say special category status, what are we looking at? We are looking at the economic prosperity. We are looking at providing certain means and mechanisms so that the state is able to empower itself over a period of time. But when we say special status, it is given to the political nuances. So what is this article speaking about? So this article currently says that Bihar Cabinet passed a resolution requesting the center to give special category status to the state. So what is it looking for? It is asking for the economical sanction from the central government. And when we say special category status, we have to understand a bit of history as well. Why do we have this concept of special category status? When we speak about the special category status, it was introduced back in the year 1969 on the recommendation of the 5th Finance Commission to benefit certain backward states having hilly terrains, strategic international borders, economic and infrastructural backwardness. So when did it come into picture? It came into picture back in the year 1969 on the recommendation of the 5th Finance Commission. So basically you had the deputy chairman of the planning commission back then, who happens to be Gadgil. What does Gadgil say? He says that there are few states. These states are, when you compare and juxtapose two kinds of states, there are one states who are economically poor. These are the states which are prosperous on one side, and we have another state which is economically on the weaker section. So we have to uplift these states primarily because they are economically backward. The infrastructure for these poor states will also have to be improved over a period of time, and as a result they came up with a designation called as the special category status. So what is the special category status, and what is the criterion on the basis of which a state is given the special category status? They need to have hilly or difficult terrain. Let's say for example we have Manipur or Meghalaya or Sikkim or Tripura or Arunachal Pradesh or Mizoram or Uttarakhand. These are the states which have hilly and difficult terrain. So we have to empower them. They cannot develop their states because they have hilly terrain. They have remote corners of the country. They do not have much of means and mechanisms as well. Let's say for example, if you are speaking about Maharashtra or you are speaking about Tamil Nadu or you are speaking about the state of Karnataka, they are economically empowered. They have means and mechanisms. They would be able to somehow make money, and they also have finances as well. They can also construct roads and come up with multiple activities. But if you consider the northeastern states, for example, they have a huge forest cover. These huge forest cover are also the carbon sinks as well. So if they also start coming up with all the developmental activities, then these carbon sinks will also be lost, and at the same time the monsoon pattern may also change as well. So we are saying, don't develop these places. We will provide you the economic prosperity, we will provide you the finances, so that you can also provide all these infrastructural support. So because they have hilly and difficult terrain, they would not be able to execute the developmental activities. So we are saying them that we will provide you, the central government is saying these states that we will be providing the means and mechanisms so that you develop. Don't hurt the hilly terrain, don't get into the deforestation process, but because you have certain disadvantage, we will provide you the money. So the first criterion is hilly and difficult terrain. Then they also have low population density or a sizable share of the tribal population. So since the tribal population is more, we are going to provide you the means and mechanisms to empower this tribal population. They must be in a strategic location along borders with the neighboring states. Let's say for example Arunachal Pradesh, it is along the border areas. It is also an area where we have constant friction with China as well. So it is a neighboring country, and at the same time, let's take the example of Uttarakhand. There have been issues with respect to China and India also on Uttarakhand front as well. Since they are on the international border, protecting them, providing them economic means also becomes important. Then they must be economically and infrastructurally backward, and they must not have non-viable nature of state finances. If they are able to meet these criterion, that state will be given what is called as special category status. So what we have is the requirement of all these criterion that has to be met. You meet up these criterion, we will provide you that special category status, and this was originally envisaged by the 5th Finance Commission and under the deputy chairmanship of Gadgil back in the year 1969. Which states currently have the special category status? We currently have Assam, Nagaland, Himachal Pradesh, Manipur, Meghalaya, Sikkim, Tripura, Arunachal Pradesh, Mizoram, Uttarakhand and Telangana. These states have been accorded the status as they share borders with other countries. Odisha lacks this requirement. Bihar lacks this requirement. Andhra Pradesh, which was also asking for it, is yet not given the special category category status. So why they have been denied the special category status? So it is not only Bihar which is asking for the first time. Bihar has also asked for the special category status in the past. Then we also have Odisha which is asking for it as well. It is yet not being given the special category status, primarily because of what has happened in the recent past. In the recent past, if you consider the 14th Finance Commission report, the 14th Finance Commission report basically said that what we have is a devolution of funds. What is devolution of funds? We have vertical devolution. We also have horizontal devolution. What is this vertical devolution? Devolution is, let's say for example, we have the central government, we have the consolidated fund of India. Let's say the entire funds, the revenue that the central government receives is goes into the consolidated fund of India. Once it goes into the consolidated fund of India, how much of this money should go to the state governments? How much of this money should go to the central government? So that is what the function of the Finance Commission is. So the Finance Commission will look into all the attributes and will look into the various parameters and ultimately conclude so and so percentage should go to the central government, so and so percentage should go to the state government. So accordingly, the 14th Finance Commission came up with a recommendation which said, according to 13th Finance Commission, 32% should be going to the states, but this was increased to 42%. So according to the 14th Finance Commission, 42% of the finances that is present in the consolidated fund of the country will go to the states, and that is what is called as vertical devolution. So what is vertical devolution? How much of money will go to the central government? How much of money will go to the state government? That is vertical devolution. So the 14th Finance Commission said 42% should go to the state governments, which is why multiple states have been requesting for the special category status, that is, give us the special category status because we are poor, because we are backward, we do not have infrastructure. But what has the central government said? The central government said that in the 14th Finance Commission, we have increased this number from 32 to 42%, and whatever finances has to be provided, we are already providing through these mechanisms. So we are not going to provide special category status, said the central government. And what is this vertical devolution? Within the states, 42% has been given to the state governments. And how much should be given to each of the state? Let's say for example, the state of Maharashtra or the state of Tamil Nadu or the state of Kerala, how much percentage within this 42% should be decided will be decided on the basis of the horizontal devolution. So that is what is happening. So these states have been constantly requesting for these kind of special category status, but the central government is denying, primarily because that 42% has been sanctioned under the 14th Finance Commission, and the states have been getting more money as well. What are the benefits in case they do get the special category status? What is the advantage? What would be the benefits of it? Under this status, the government pays 90% of the funds in the schemes that the center sponsors. There are two kinds of schemes. One is a central sector scheme. The other is a central sponsored scheme. What is the central sector scheme? When we speak about central sector scheme, in the central sector scheme, what we have is the government which makes 100% of the contributions. It is the responsibility of the central government to make 100% contribution in central sector scheme. What is centrally sponsored scheme? In the centrally sponsored scheme, a certain percentage is given by the central government, a certain percentage is given by the state governments. For example, if it is given a special category status, 90% of the funds is contributed by the central government, 10% is contributed by the state governments. But when it comes to the other states, about 70% or 65% is 65 to 70% is contributed by the central government. The rest 30% will be contributed by the state governments. So regular state get 60 to 75% of the fund from the center under the same scheme. So if they are centrally sponsored scheme, if they are, let's say for example, special category status is provided to them, in that case 90% will be contributed by the central government, only 10% will be contributed by the state governments. But in rest of the other states, there will be 30 to 35% which will be contributed by these states. The other part, that is around 60 to 75%, will be contributed by the central government, which is why they are seeking for it. And at the same time, in case of unspent money, the states with the special category status have the provision to take it forward. So let's say if they are not able to spend within one financial year from March to April, then the same amount will be retained with the state governments. They can take it forward for the next year. But for the other states, if they are not able to spend, it goes back to the state exchequer. These are some of the advantages, and at the same time they are also given tax incentives as well. They are also provided infrastructural support as well, and all these supports, corporate tax support, income tax and other taxes to basically attract the investments, will be provided to the special category status, which is not provided to the normal regular states, which is why these ones, that is the Bihar, Odisha and Andhra Pradesh, have been seeking for the special category status. So the states also enjoy significant concession on excise, custom duties, income tax and corporate tax, so on and so forth, which is why they continuously ask for it. However, the central government in all likelihood may also deny this recommendation or the resolution passed by the Bihar government, because it has already sanctioned more amounts at the 42% as per the recommendations of the 14th Finance Commission. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says same-sex couples, a judge to the rescue. We have discussed about the same-sex marriage issue that the Supreme Court had recently discussed. I have recorded an elaborate video both in English as well as in Kannada. For those of them who are preparing for KPSC, I have recorded another video which has both in English as well as in Kannada, and this is where the Supreme Court said that right to marry is not a fundamental right. It also said that we have the Special Marriage Act. Under the Special Marriage Act, it recognizes the heterosexual couples. Who are these heterosexual couples? A man and a woman getting married. They have their certain rights that are accommodated. This is what is recognized under the Special Marriage Act. Is the relationship between the homosexual couples recognized under the Special Marriage Act? No. Which is what the Supreme Court said, that in the majority perspective, that is 3:2 judgment, they went on to say that if there are homosexual couples, that is a man and a man wanting to get married, a female and another female wanting to get married, in case they want to sustain a relationship, want to have a wedlock, in that particular case, it is not recognized under the Special Marriage Act. This is what the Supreme Court said in a 3:2 judgment. Now, in what could be a possible departure from this and a new judicial innovation, we have a new interpretation made by the Justice of Madras High Court in the new judgment called as Sushma versus Commissioner of Police. So what is this judgment all about? We will take it up in some time, but before that, what I want you to do is, I have recorded a video for the same in the name of same-sex marriage Supreme Court verdict. So kindly look into it and then come back to the video. We will not be discussing about what the Supreme Court judgment was with respect to that landmark judgment. We will not be looking into it, where we discussed about the Superior judgment versus the Union of India in an elaborate way, but what we will be focusing is only with respect to this judgment made by the Madras High Court. First, before we understand what this Madras High Court judgment is all about, we have to understand principles called as Yogyakarta principles. What is this Yogyakarta principles? Remember, Yogyakarta happens to be a place in Indonesia. This can also be very important from the preliminary examination point of view. So what is this Yogyakarta principles? We have human rights which are recognized world over. However, there can be discrimination which can be conducted in multiple ways and paths. For example, a person of a different race can be discriminated, a person of a different religion can be discriminated, a person of a different language can be discriminated. So discrimination can take any of its form. Similarly, there can be people who would have a specific gender identity and sexual orientation. What do I mean by sexual orientation and gender identity? When I say gender identity, at the time of a birth, a person may have been given a specific gender based on the physical attributes. For example, based on the physical genitals, a person may be given as a man or a woman. But then over a period of time, what would happen? A person may start assuming that despite that person having a female genitals, the person starts assuming that he is a man internally, or it can be the other ways as well. There can be a man with the male genitals, but this person may start assuming that he is a female as well. So what we have is gender dysphoria, which basically means that there is a presumption and an assumption, and they basically believe that they are a person of a different gender. So that is what is sexual orientation. So a person of a specific gender may recognize that he is of an opposite gender, and a person of a specific gender may also have trace of another gender as well. So what is the Yogyakarta principle speaking about? The Yogyakarta principle says that we have seen discrimination of all kinds of discrimination. It can be with respect to the race, religion, so on and so forth. The Yogyakarta principle basically looked at discrimination on the basis of gender identity. Yogyakarta principles, which happened in Indonesia, emphasized on the fact that there is discrimination on the sexual orientation, discrimination on the gender identity. So we have to rework on it and ultimately provide dignity to these individuals whose dignity has been violated time after time. So those people who have been discriminated because they have a different sexual orientation and a gender identity, their rights are getting violated. So recognition of these is what is discussed under the Yogyakarta principles, which took place in the country of Indonesia. So Yogyakarta happens to be a place in Indonesia. Since these principles were discussed in that is why it is called as Yogyakarta principles. Remember, the United Nations does not recognize these Yogyakarta principles, which can be another important pointer from your preliminary examination point of view. What are the major principles of the Yogyakarta principles? When we speak about Yogyakarta principles, it says rights to universal enjoyment of human rights, non-discrimination and recognition before law. So the preamble of the Yogyakarta principles primarily say that there are some specific human rights. These human rights would also have to be given to these people. There should be no discrimination as well. All the rights that are accorded to the individuals under the law of the country, the same should be accorded to that individual who has a different sexual orientation and a gender identity. So the Yogyakarta principles is about recognizing these human rights for all these people who have been discriminated. So if we have to look into the principles per se, the principles 4 to 11 addresses fundamental rights to life, freedom from violence, torture, privacy, access to justice and freedom from arbitrary detention. So these people may not have been given certain rights. For example, their privacy may not be respected. They are forced, and as a result they are forced to change their mental way of thinking as well. So they go through physical torture, they go through mental torture, and they would not be provided right to life to live with dignity. So these principles will have to be reinforced, that is, they should be provided right means and mechanisms. Similarly, principles 19 to 29 emphasize the importance of freedom to express oneself, one's identity and one's sexuality without state interference based on sexual orientation or gender identity. Similarly, principle 22 and 23 highlight the rights of the persons to seek asylum from persecution based on sexual orientation, and principles 24 to 26 address the right of persons to participate in family life, public affairs and cultural life of their community without discrimination based on sexual orientation. So what is principle 24 to 26 speaking about? It is speaking about family commitments. What is it speaking about? It is speaking about two homosexual couples wanting to start a family. In case they want to start a family, let's say they become kind of husband and wife relationship. In that case, they do have certain rights as well. They do have rights that derive from a relationship. This should be recognized under principle 24 to 26. To give boost to this principle 24 to 26 as part of the family recognition, we have the Madras High Court, which has now said that in Sushma versus Commissioner of Police, the Madras High Court has asked the state government to come out with a deed of familial association. So what is this article speaking about? This article says that we have something called as the deed of the familial association. What is this deed of the familial association? This deed of the familial association is basically a kind of a contract. It is kind of an agreement. What would happen in the deed of the family contraction? In this particular case, what would happen? these people would have entered into a relationship. What the Supreme Court has reiterated in the past, and it has also reiterated in the recently discussed judgment, is they would be able to enter into a relationship, but that may not be recognized as a marriage under the Special Marriage Act. So what has the Supreme Court confirmed? That they would be able to enter into a relationship. Because they would be able to enter into a relationship, this also basically means that they should not be harassed, there should be no physical torture per se, they should be allowed to live in their own terms and conditions, which is what is this deed of familial contraction. So basically, when we speak about this deed of the familial association, these people who are in a relationship, they should be prevented from being harassed over a period of time. So whatever principles have been given in 24 and 26 of the Yogyakarta principle, that should be applied as part of the deed of the familial association, since the relationship is established and espoused and supported by the Supreme Court of India. These people may not be allowed to get married, these people may not be allowed to form the civil union, but they have certain rights and they should be prevented from harassment. So preventing these people from all these harassments is what is called as the deed of the familial association. So basically, protecting these non-heterosexual couples, that is the homosexual couples, from harassment and violence, including from the biological families, in case their parents are opposing it, brothers and sisters are opposing it, cousins are opposing it, relatives are opposing it, preventing them from the harassment and also violence is what is called as the deed of the familial association. Since there are some rights that are given as part of the family to these section of the people, the same will have to be recognized, says the Madras High Court. So the Madras High Court has directed the state to consider this particular proposal. Why? Because the Supreme Court has said that this happens to be a domain of the state governments and the central governments. Why? That is because when it comes to making a legislature, it is the domain of the legislature who have to come up with the laws. So what has the Supreme Court said? The Supreme Court had said that they cannot enter into a wedlock, or this cannot be recognized, but this realm falls under the domain of the legislature. So what is the author trying to say here? The author says, at a minimum, establish the framework to recognize such relationship through registration of such deeds. However, much more is possible. The state government could enact legislation creating the institution of civil unions and accord such date to the same-sex couples. The Supreme Court rationale is that it is the business of the legislature. Even more laws relating to marriage, divorce, inheritance, succession, minors, adoption, etc. are all present in the concurrent list under the 7th schedule to the Constitution, thereby giving the powers to the state to legislate. So in the present situation, the Madras High Court has asked the state to look into this proposal of deed of familial association. Directions have been issued. So when the state government is coming up and understanding this proposal, since certain things falls under the concurrent list, they would be able to make laws. So we are not going to violate the Supreme Court judgment. The Supreme Court judgment said ultimately it is the legislature who have to make the laws. Since state governments also have the power under the concurrent list to make laws with respect to marriage, divorce, inheritance, so on and so forth, why not recognize the Yogyakarta principles? Why not take an interpretation of principle 24 to 26 and give it a new meaning in the form of deed of familial association, so that there are some rights that are given to these people. So basically, when we say that deed of familial association is given, familial association is given, there should be no discrimination, they should be able to live with dignity, and at the same time they should be able to execute the family responsibilities which is envisaged under the Yogyakarta principles, and at the same time there should be no harassment whatsoever, primarily to prevent these people to execute and live their life the way they want, is what is this deed of familial association. So we have the Madras High Court in the landmark judgment of Sushma versus the Commissioner of Police asked the state government to come up with this particular deed called as the deed of familial association, is what is this article all about. Now let's look into the next article. This article says, listen to the people, not the numbers. What is this article speaking about? The article here is primarily speaking about the economy of the country. The article says that when it comes to the overall economy of the country, what we are seeing is a significant boost in the economy. The GDP numbers are increasing over a period of time, but this ultimately is also coming to a conclusion that the GDP numbers are increasing, but then the people's income are not increasing. So country as a whole is growing, but then people are not empowered over a period of time. This is where we have two concepts. One is what is called as the jobless growth. It was a question that was asked in the UPSC, I think probably in the year 2016 or 17. One is what is called as the jobless growth. Then what we also have is another example which is called as the treadmill economics. What is this concept of treadmill economics or this jobless growth? When we speak about the treadmill economics, what happens in a treadmill? Let's say for example, you are running on a treadmill. Are you really running and taking a distance? No, you're not moving from point A to point B, but all that you have is a machine. You're running on that particular machine. So you are actually burning your calories, but at the same time, you're not moving anywhere, but you are in that static position. Similarly, treadmill economics basically says that the country is growing, that it feels like the country is growing, but we are not moving further in terms of the economic income generation. So jobless growth also says that country is growing over a period of time, but then individuals are not able to generate enough income as well. So what is the major factor here? That when it comes to the jobless growth, when it comes to the economy, you have massive number of rich people who are able to contribute. They are making a lot of money, but then there are people who are not able to make the income generation. That is because they may not have the skill set. That is because they might not have the required money to also contribute, and at the same time they do not have the means and mechanisms to get empowered and have the required skill set over a period of time. So the country as a whole is becoming rich day by day. GDP is increasing, but the people whose income has to increase, that is not happening. Is what is this jobless growth or the treadmill economics? So the author in this particular case also re-emphasizes the very same fact that we may be growing as well, but when it comes to the real growth about the income of the people, that is not working, says the author. So the author takes up a couple of examples. He says incomes are not growing sufficiently or sustainably for very large number of people, even though overall GDP is growing. The author takes the example of US economy, where the author says growth is good and employment numbers have also been improving in United States of America. However, people want more in United States of America. One is to secure incomes to cope with the inflation, and at the same time, people in United States of America also feels that there are people who are working in the manufacturing sector and in the lower rodent sector where they are putting in a lot of efforts, but most of the money is garnered by the CEOs, and this is not going to the people of late. So the CEOs of auto companies were paying themselves far too much in excess, but that is not being paid to the small number of people who have to be the lower rung people. For them, it is not being provided. And added to it, when we speak about India, why is that we have the jobless growth? That is because people do not have enough skill set, and also because of the metamorphosis and the transformation that India as a country took through. Whenever we speak about a country, we have three sectors: agriculture sector, manufacturing sector, and service sector. Every country will take a transition from the agriculture sector, it will go to the manufacturing sector, and ultimately what we will have is the service sector. This is how the transition for most of the countries, for example United States of America or China. In fact, China is also called as the manufacturing hub because a lot of empowerment and means and mechanisms were provided by the government. So agriculture to manufacture, and from manufacture to service is what the transition process is. But what did India do? Immediately after 1990, when liberalization happened, India directly moved from agriculture to the service sector. In fact, more than 60% of our entire GDP and the income that we generate in our country is primarily from the service sector, and as a result what we have seen is that the manufacturing sector has not worked, and people who have to move from the rural areas to the urban areas, they do not have the skill set to actually enter into the service sector, provide the services that is required, but instead they move from the agricultural sector to the service sector. That is not possible, and the kind of quality of the jobs that are created in the agriculture and the market sector is not enough, and as a result they are not not able to get good jobs. 1990s, we directly moved from the agriculture to the service sector with a boost in the growth of export information technology services. Jobs they have, irrespective of the sector, are not good jobs. They do not pay enough. They are all temporary. They are all contractual workers. They do not provide social security or assistance, and contract workers are paid way too less than the regular workers. In fact, as we have discussed, we have more of the gig workers of late. There are also contractual workers of late, and these people are not provided any of the social security like the PF or, for example, the health insurance. These are not provided to the people in this particular locality. So what is the author saying? The author says that new ideas of economics are required to create a more environmentally sustainable, socially harmonious future. Economists should also measure women's participation in the labor force. They should value women who do formal work in the informal sector, and there are also women who are acting as the caregivers. They should also be represented. They should be given more empowerment means and mechanisms, and the process of policy making must begin with listening to those who have not been given much value in the present economic paradigm, that is the workers, small holding farmers, small entrepreneurs and the women. Their voice will also have to be heard, and ultimately a change will have to be brought about and a transformation will have to be taken up so that we would empower all those people and the incomes also take a boost over a period of time, is what is this article all about. Now let's look into the next article. This article says a dilemma over tribal land rights. This article here is speaking about Orissa Scheduled Areas Transfer of Immovable Property by Schedule Types Regulation Act of 1956. What did this law speak about? This law basically prevents the tribal lands from being moved from the tribal lands to the non-tribal people. So recently there was an amendment. According to this amendment, it said a scheduled tribe person may, with the written permission of the sub-collector, make a gift or exchange for public purposes or obtain a loan by securing a mortgage in a public financial institution for agriculture, construction of residential home in favor of a person not belonging to a scheduled tribe for the above reason. What does this mean? These are the lands that are held with the tribals. So this should ultimately lay with the tribals as well. But this amendment that was introduced in the regulation basically said that the tribal people would be able to sell this land to a non-tribal person, but with a caveat. The caveat said that these people, if they are selling the land, the tribal person should not be homeless. So such a transfer, the tribal seller or mortgager should not be landless or homesteadless. The OSTP includes strict provisions that not only prohibit the transfer of tribal lands but also criminalize any forced alienation. And at the same time, it said the tribals would be able to sell or mortgage their property to the non-tribals, but they should be provided an alternative in the form of land. But this is where the author says that this can create a lot of problems to the tribals. Despite this law persisting and saying that they should not be forced, they can be forced to sell their lands, and they might also be given a land in some other place. So giving a home is what is important, or a property is important. So this particular land may be taken by the mafia and they might be given an alternative land from somewhere else where they would not be able to create means and mechanisms for their livelihood. And when we speak about the tribal community is happy and complacent the way they are. They are happy, they do not want wealth gathering, they are not materialistic as whole. But when you start doing such activities, they may change their perception towards the life as well. In fact, the Comptroller and Auditor General, which carried out random study, found that the land held by tribals in Odisha had decreased by 12% in the decade between 2005 to 2015 and 16. It had happened despite OSATIP being in force as well. If such lands are moved from tribals to the non-tribals, this will be an attack on the tribal identity. There can be a demographic change as well. Why? Because the non-tribals will enter into the tribal heartland, and the term landless or homesteadless are yet not clarified and defined in this regulation. Since there was a lot of hue and cry from the protectors of these tribals and activists in place, this amendment has been kept on hold for a short period of time. In 2010 as well, the amendment seeking permission to transfer the tribal land was turned down by the President of India. So what they have done right now is a temporary pause in executing this regulation, where land will be moved from the tribals to the non-tribals. That is one part. And that apart, remember, we have demographic change that can happen, attack on the tribal identity, and what is this landless person, what kind of home is given is yet not defined properly. It is very vague as well. This can lead to a lot of problems for the for the tribal identity of these individuals, and as a result there is a stay of the execution of this regulation. That is what this article is all about. Now let's look into the next article. This article says, what is the ruling against UK's Rwanda deal? This article here is speaking about migration and economic development partnership. What is this migration and economic development partnership? This was introduced back in the year 2022 by whom? By the former Prime Minister Boris Johnson of United Kingdom. What is this migration and economic development partnership? Let's say, for example, there are individuals who have come from Africa. They've moved all the way from Africa or other places, and ultimately they are planning to enter the United Kingdom. Why? Because there is some kind of political turmoil that is happening in some of the parts of Africa, or there can also be people who are seeking for an asylum in United Kingdom. So what did United Kingdom say? United Kingdom said that if you are coming from Africa or any of the other parts, we are ready to accommodate. Yes, you are asking for what is called as the asylum, where you are seeking for protection as well. We do understand all of that, but we would not be able to accommodate you in United Kingdom, but we will provide you an alternative window where all those people who are coming via the sea or taking any other routes, if you're planning to come to United Kingdom, we will provide you the transition. That is, in case you are wanting to move to United Kingdom, we will not be accommodating you in United Kingdom, but we will be taking you to Rwanda, and the transition fee and the accommodation fee will also be given by United Kingdom. So the objective of the deal is to create a mechanism for the transfer of asylum seekers not considered by the United Kingdom into Rwanda. So those who are seeking for the asylum, when they go to United Kingdom, they would not be taken there into United Kingdom, but then they would be provided and asked to go to Rwanda. Is what is this migration and economic development partnership all about? Why was Rwanda chosen in the first place? That is because Rwanda offers 3 solutions for those sent by UK. It facilitates returning them to the country of origin. So in case people are asking for the asylum, when people are accepted into Rwanda, it can speak to that home country, native country, and ensure that right circumstances are put in place in a home country, and these individuals are asked to go back to their country, help in moving to a third country. So instead of United Kingdom or Rwanda, they will be asked to move to a third country. Such will also be accommodated by this particular deal as well. And third, they will be allowed to settle in Rwanda with decent housing, access to universal health insurance, and the right to work. So United Kingdom will bear the accommodation and the transit cost, and Rwanda was not the first country to be approached. We have similar such examples in the past, where we have the colonial power which is actually in talks with another country so that they can actually migrate and export these people to another country. That is what is this migration and economic development partnership all about. But recently we have the Supreme Court of United Kingdom which has declared that such migration and economic developmental partnership is unconstitutional. Why? That is because of the principle of refoulement. What is refoulement? Let's say, for example, there is an individual. For example, let's take the example of Myanmar, or let's take the example of, let's say, Palestine in the present situation. What is refoulement? Refoulement basically is that there is a political turmoil in a country, either on the basis of religion or on the basis of language. So these people are moving from one country to another, Palestine to Egypt, or let's say, for example, Myanmar to Bangladesh. So if people from Myanmar are moving to Bangladesh, or people from Palestine are moving to Egypt, if these people like Egypt and Bangladesh do not support these political asylum seekers and asking them to go back to their home country, that would lead to death of these individuals. So asking them, forcing them to go back to the country of origin because they would not want to take these individuals is what is called as refoulement. So the minute they go back to their home country, they may lose their lives as well. They were seeking for asylum in another country, but that country will not allow these people to enter their home country, and as a result what we have is these individuals individual who are asked to go back, and when they are asked to go back, that is what is called as refoulement. So the Supreme Court has said that when they are asked to go back to their home country or to Rwanda, there are risks of refoulement, and this could also lead to loss of lives as well. And as a result, it has declared the Migration and Economic Development Partnership as illegal and unconstitutional. So remember, the Migration and Economic Development Partnership was envisaged in 2022 by then Prime Minister of United Kingdom, where all those people who are seeking asylum and coming to United Kingdom are asked to go back to Rwanda, and basic necessities will be fulfilled by United Kingdom. This is what is the Migration and Economic Developmental Partnership, which has been declared as unconstitutional, illegal by the Supreme Court of United Kingdom. It is this that we have to understand with respect to this article. In case you are liking these initiatives, again, please do like these videos, subscribe to our YouTube channel, and also share it with your fellow aspirants as well. This is it for today. Thank you for watching. All the best.